In this video, I'm going to look at one of the values that people assert are relevant to choosing a theory of constitutional interpretation. The concern is typically labeled judicial activism, and this term is largely used as a derogatory term to refer to cases in which judges are alleged to create new law rather than interpreting and applying the law as written. It's asserted that judges create new law by interpreting a law or the Constitution so that it says what the judge wants it to say. Before we get into this discussion, I want to identify a very popular but very bad argument one often sees in the public regarding constitutional interpretation. This form of argument begins with the objection that some judge that claims to adhere to a particular philosophy of interpretation in fact uses that system to impose their values on the country. The critic then draws the conclusion that the fault is in the interpretive system rather than the judge. Without naming any names or giving any examples, the problem with this argument is that there is no interpretive system that doesn't allow for the possibility of rationalization and misuse. So if the fact that an interpretive system can be misused means that it must be rejected, then every interpretive system must be rejected, because every interpretive system can be misused. Setting that bad argument aside, is there a good reason to be concerned about judicial activism? And if so, which interpretive system best deals with this issue? Originalists often assert that one of the main advantages of originalism is that it is the best system for avoiding the problem of judicial activism. Judges are tasked with determining what the law says. There is a method for determining what the law says that leaves little room for judges to insert their opinions and prejudices. Thus, it is capable of being more objective and neutral than other interpretive theories. In contrast, living constitution theories allow judges to insert their ideas on what counts as the evolving moral standards, which all too often is nothing more than the judge's own moral opinions. Moral fact theories allow judges to insert their opinions about the moral facts into the law. Originalism dismisses the judge's opinions about evolving moral standards or so-called moral facts as irrelevant to determining what the law says. Chief Justice John Roberts, in his confirmation hearings, described his adherence to this position as follows, quote, "I will be open to the considered views of my colleagues on the bench, and I will decide every case based on the record, according to the rule of law, without fear or favor, to the best of my ability, and I will remember that it's my job to call balls and strikes, and not to pitch or bat." End quote. The role of an umpire is to enforce the rules that are written, not to change the rules in favor of this or that team, or to change the game in a way that the umpire judges to be better. Judicial activism at the level of the Supreme Court, it is argued, effectively means that 5 unelected judges holding their position for life have the power to create amendments to the Constitution. The legitimate amendment process requires a vote of 2/3 of each House of Congress to propose an amendment to the states, and then ratification by 3/4 of all the states. That currently is 38 of the 50 states. But if 5 unelected lifetime judges decide to grant the government a new power or to create a new right, it is extremely difficult to stop them. Defenders of originalism have long pointed to the decision of the 1973 case Roe v. Wade as an example of judicial activism. In this decision, the court, in a 7-2 vote, held that the Constitution of the United States implied that women have a right to an abortion. However, in explaining the limits of this right, the Supreme Court created a set of restrictions and qualifications that looked much more like a law than a constitutional principle. During the first trimester of pregnancy, a woman could terminate a pregnancy at will. During the second trimester, a woman could terminate a pregnancy, but under conditions prescribed by state law so as to protect the life and health of the mother. During the third trimester, when the fetus could survive outside the womb, the state could ban abortion. To an originalist, it's simply absurd to think that all of this detail and complexity can be found in the words of the Constitution to be discovered by judges. Instead, they assert the majority in this case didn't find this in the Constitution. They manufactured this right in their own mind and then used, or they would say abused, their power as Supreme Court justices to impose their law on the rest of the country. In the case of a genuine law with this level of complexity, we would expect that the legislature would need to revisit it from time to time to adjust it to fit a number of complex and confounding circumstances. In making their decision, the originalists charged, not only did the majority create a new law, they created a law that is extremely difficult to revise or update. Furthermore, originalists see the fact that the judges who created this law are appointed rather than elected compounds the problem. The making of needed revisions and adjustments are removed from the legislative process. If the legislature passes a law the people don't like, the people have the opportunity at the next election to throw those legislators out of office and elect new legislators that will make laws more to their liking. When the Supreme Court creates a law, or more precisely, creates an amendment to the Constitution, the people are forced to live with it, whether they like it or not. Overturning Roe v. Wade means that the decision as to what the law will be will no longer be up to judges. It'll be up to state legislators, who can revise the statute to keep it in line with the mood of the public. If a legislator bans abortion, and the voters disapprove of the ban, then during the next election the voters can select a different set of legislators. So, let's consider some objections to this line of reasoning. The first of these objections is that the Constitution aims to provide limits to legislative power. Some questions should not be left up to the legislature. Imagine a country in which state legislators had the power to decide if slavery would exist in their state or not. We may suspect that the results might be less than ideal, and that to prevent this, it's perfectly legitimate to prohibit states from even considering whether to enslave a segment of its population. That is to say, there are certain rights that governments may not infringe, even if the majority of voters want to do so. In some cases, authors may use vague and ambiguous language as a way of covering over disputes among the participants. Disputes about what types of laws the legislature is allowed to pass can be glossed over by giving the legislature the power, quote, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, unquote. Two people who have different ideas on what it takes for a law to be necessary and proper can vote to approve the same language, even though one intends the language to allow something that the other intends it to prohibit. For a judge to dictate that one interpretation is correct and the other incorrect is to take sides in a dispute that the authors themselves were unable to resolve. Another problem is that questions of interpretation are not always easy. I want to illustrate this with an example in which it's a mistake to take something written at face value. On January 1, 1863, President Abraham Lincoln issued the Emancipation Proclamation that freed all slaves in states still in rebellion. This was not a power granted to the president by Congress. This is a power that Lincoln assumed in his role as commander-in-chief. The reason that the Emancipation Proclamation took the form that it did, freeing slaves only in states still in rebellion, for example, is because it had to fit within the president's power as commander-in-chief. Pro-Confederate Americans who try to argue that the Civil War was not about slavery like to point to the following quote in Abraham Lincoln, quote, "If I could save the Union without freeing any slave, I would do it. And if I could save it by freeing all the slaves, I would do it. And if I could save it by freeing some and leaving others alone, I would also do that." End quote. This is meant to show that Lincoln was not fighting to end slavery. In part, it's true, Lincoln was fighting to preserve the Union. However, this is the same Lincoln who said that the nation cannot survive half free and half slave. So preserving the Union meant preserving a nation that was either all slave or all free. Of the two, Lincoln clearly preferred a Union without slavery. The context of this quote helps to determine its meaning. Lincoln wrote the Emancipation Proclamation and presented it to his cabinet in July of 1862. When his cabinet began to debate whether this was a good idea, Lincoln informed them that this was not up to debate. This was going to happen. He was convinced, however, to put it all off until there was a Union victory, so that it would not look like an act of desperation. Lincoln put the Emancipation Proclamation in a desk drawer. Now, Lincoln strongly suspected that the Emancipation Proclamation will be challenged in court. Lincoln knew that the president does not have the power to amend the Constitution by means of presidential order. So he had to make sure that when the Emancipation Proclamation came before the Supreme Court, it could be defended as an act that he took in his capacity as commander-in-chief, as a legitimate war aim. So in August, he wrote a letter to Horace Greeley, editor of the New York Tribune, in which this quote appears. For all practical purposes, what the quote says is, "Hey, Supreme Court, I did not sign the Emancipation Proclamation in an attempt to amend the Constitution by executive order. I did it to win the war. See, look at this letter. It proves my intention." Union General George McClellan scored a victory of sorts at Antietam on September 17th, allowing Lincoln to issue a preliminary Emancipation Proclamation on September 22nd. On January 1st, 1863, the Emancipation Proclamation went into effect. Now, what's relevant for our purposes here is what it says about how to interpret Lincoln's statement in his letter to Horace Greeley. Pro-Confederate Americans take it as a statement that Lincoln cared nothing about slavery, and the plain words of the text seem to suggest that interpretation. But in the larger political context, it was a message sent to help to defend the Emancipation Proclamation if it was challenged in the Supreme Court. And the Emancipation Proclamation was meant to help ensure that the Union was preserved and slavery was not. A final objection to consider is in the claim that originalism serves as a defense against judicial activism while the competing theories do not. A living Constitution theorist can deny that their theory allows for judicial activism. Under the living Constitution philosophy, judges are required to consider the practical effects of a decision and evolving moral standards. Judges are not permitted to consider their own whim. Against the objection that the living Constitution philosophy makes it easy for judges to see what they want to see when trying to determine the practical effects and evolving moral standards, the living Constitution theorists can assert that originalists seem to do just as good a job in seeing what they want to see in the original public meaning of words and phrases. Moral fact theories can object that their theory also prohibits judges from basing decisions on their own preferences. They require that judges render decisions that are in accordance with the moral facts, and particularly to those moral facts that the authors of the Constitution referred to with terms such as due process and cruel and unusual punishments. Now, if the originalist is against judges imposing their philosophical views on the population, then the originalist needs to explain how they justify imposing the philosophy of originalism on the population. The real question is not whether to impose a philosophical view when interpreting the Constitution, but which is the best philosophical view to use. So the principle that we're looking at says that justices should enforce the law, not create the law. And this means that the primary job of a judge is to determine what the law is, not what the justices want the law to be. Defenders of originalism, with its focus on the original public meaning of the law when it was written, argue that this leaves little room for judges to impose their personal philosophies on the people. There are other concerns that we need to consider. Next, I will turn to the concern that it's unwise for us to bind ourselves to rules written 250 years ago by people living under entirely different circumstances and who lacked the knowledge and understanding that we have acquired in that time.